safeguarding your future legal planning for peace of mind. So some of us can spend more time worrying about things. Well, if we would just take a few action steps and have plans in place that could reduce worry to ourselves and give our family peace of mind too. Now, our kids may also be worrying, oh no, what if something were to happen? What would we do? Who would we call? Well, be prepared. And so we're going to be focusing on the legal part today. So I'm really thrilled to have with us James Rainey from Rainey & Rainey Attorneys at Law. I hope I had the right title.
That is correct.
Yay. So James, you want to go ahead and introduce yourself?
Good morning. My name is James Rainey. I am an elder law attorney, estate planning attorney with offices here in Georgetown and in Waco. We represent clients all the way from Austin through Waco. And we've been doing this 30 years. My wife and I started the firm about 30 years ago. We teach elder law at Baylor School of Law, and we've really grown. We have about 5 attorneys now, and this is what we do, and we're very excited to be here today.
Yeah, I'm on here too. Okay. So we're thrilled to have you with us. And again, certainly want to be aware of Rainey & Rainey Law Firm. But again, he's helping us just understand the whole legal world as it affects seniors. So that's so important. Some of our topics, our discussion points today, many of you are going to say, well, I already know that. Then that's great. Give yourself a slap on the back. Yay, I am informed. But you know, there are also probably few little twists or turns or things we need to be aware of. So I think there'll be something for everybody. Okay, so let's just start with the basics. You know, when we talk about estate planning, we're going to talk about the financial aspects on another seminar, but tell us a little bit, why is having a will so important, and what are the risks of not having a will?
Yeah, so, you know, when we start talking about estate planning, we start talking about how are we going to transfer our property, the things we own, our money, our bank accounts, our house, our car, our personal belongings, to our children, to our spouse, or whomever we want it to go to when we die. And we need to make a plan and an arrangement to move those assets when we die. And the most common way to do that is through a last will and testament. So a last will and testament is a document where we get to decide who gets our property when we pass away. We can also attach strings sometimes in our last will and testament. We can create trusts that come alive in our last will and testament when we die. We can say, well, when you pay back money you owe me to my estate, then you get this item, and we give instructions to our executor who probates our will for us. One thing that is important to understand about the last will and testament is that it is very flexible, and we truly can leave our property that it controls however we want. I can leave it all to my wife. I can leave it to my children. I can split it between my children. I can leave it to my mistress. You know, I can do whatever I want in my last will and testament, okay? But only the property that it controls. Sometimes we might have a bank account with a beneficiary on it. We might have a trust, which I know we'll talk about. Those items are not controlled by our will once we make a different arrangement for them. So we always need to keep in mind that our will only controls certain items. And one other important fact about our last will and testament is that it has to be probated, all right? Has to be probated. It is. I have people come in and see me. Mom died 8 years ago. My dad just died, and now we want to just have some questions. But Mom had a will that was never probated, and nothing got transferred to Dad's name. And that might not be a problem if all the assets are community property and all the children belong to the two of them. But if it's a second marriage or if they own separate property, then it could become a really big problem. And so I think there's a misconception sometimes in the public that just because I wrote a will, that's all I have to do. It's more.
Yeah, I want to jump in with my realtor hat on here. In fact, we see this, I just went through this spring with a woman whose husband had passed away a few years ago. Yes, there was a will, and the property, was to go to her. And so, well, no, we're all set. I don't have to do anything. Well, we are going to need to do something. No, it's my property. We can't sell your property without either, we've got to do something. And it took some time. And then she did meet with an attorney, and I need to probate his will. And here's the catch with that, too, is that sometimes it can be a length of time, especially if it gets complicated with families. And so that's one of my things. And some of you say, of course, it's common sense. You have to probate your will. Oh, no, it's not always common sense. The will doesn't do much until it is probated.
That is correct. There's no transfer until it's accepted by the court and probated.
So for some of you that may be new, some of you already knew that, but, Okay, I've had a lot of people to ask, we have a lot of people who move here for retirement. Well, I have a will, but it was done in Ohio or California, and it was done 15 years ago. Is that still good? What?
It might be. So the question is, it might be. Generally, Texas will recognize a will created in a different state as long as Texas can identify that will met the requirements of that state at the time it was signed. And if it met all of the requirements of, let's say someone moved here from Oregon, they had done a will in Oregon 20 years ago, if it met all of the requirements in Oregon at the time it was signed, when we file it for probate in Texas, the Texas will recognize that will. It's just we have to go through the extra steps of perhaps hiring a lawyer or doing legal research to make sure that Oregon will was properly done in 20 years ago in order to get it admitted in Texas.
So would a simpler version be to update a will? How often should we update? What causes us to update a will?
Yeah, so there's a will only needs to be updated when there's been a change to what we want to happen to our probate assets. Then we have to update our will. We also recommend updating and changing our will when you move states. It's just a lot easier for us to take a Texas will into a Texas court and probate it. It's faster, and often cheaper to do it that way, especially it just avoids the headache of having to figure out, does this will comply with the requirements 20 years ago in Oregon. And so otherwise, if you have a Texas will, it can be an old will, and if it was written correctly when it was written, and we're happy with the executors, we're happy with what's happening, we don't need to change it ever. But we do need to review it regularly. Whenever there's a death in the family, whenever we move, whenever somebody is diagnosed or is concerned about illness, whenever our children get married, whenever any of those types of events occur, we should automatically review our will and other estate planning. In light of this new event, is this still what we want to happen? So we always need to evaluate that.
So let's find, some of these go back and forth between trust and will, but I think I want to follow up with this one. You had mentioned transferring property, and that's one of the main things with a will. Well, any property. I look at the real estate property, and we talked about how to be prepared for that. We often have people who ask about, does that come to me automatically, or what's the deal? Do I need to have the enhanced life estate deed or ladybird deed? Or is that just related to the trust? Tell us a little bit about, some people will say, yeah, I have transfer on death. Or, some of us say there's something that makes the property come to me, but I don't know what it is. Mm-hmm. So help us understand.
Sure. So again, when we're getting ready and when we're doing our planning, we want to figure out how we're going to transfer assets to the right people on the right conditions when we pass away. That might be through the last will and testament, might be through a trust, but it might be through a transfer on death deed or a ladybird deed. A ladybird deed and transfer on death deeds are very similar deeds, but have different requirements to them. But at the end of the day, when we die, they automatically transfer a piece of property to whoever's named on that deed. So I might say, I leave my house to my children when I die, but I reserve the right to do something different with it while I'm still alive, all right? And so I write this deed up, but I still retain control, and so I can sell it, I can rent it, I can live in it, do whatever I want with it. But when I die, it's an automatic transfer to whoever's named on that particular type of deed. We use that when we do Medicaid planning all the time. It's very, very important. And then we use it in other situations as well, even when Medicaid's not involved, when we know that we want this house or this piece of property to go to a particular person when we die, or even to a trust when we die. It can be very effective. And it's an automatic transfer. I die, it's on file, it hasn't been changed or revoked. That's an automatic transfer, whoever's named on that deed.
And I think, I hope I'm going to say this right, if not, you'll correct me. I know I've had people who, a spouse had passed away, and perhaps the house had belonged to the spouse and a previous partner, but the current partner is able to stay in the house, but then it is going to go back to is that a transfer and it goes back to the family?
It just depends how you write it up. So you can write up that deed a multitude of ways, but certainly if we have a married couple or two people who are partners who own the house together and live in the house together, we will want to reserve the right for both individuals to stay there until they both die, and then when they both have passed, then it transfers. We can certainly do that.
Okay. Just something to be aware of. You know, the gossip line is always amazing, and everybody has all the information. Accuracy is not always part of that information, so that's the reason we need to know, and that's what you're finding out today. Let's jump over to the trust. You've mentioned that, and as I've often said, to me, when I thought of trust, I would think that's for people who have a business or a lot of money, and if I don't fall in that category, why would I need a trust? So who needs a trust?
Well, a trust is just another tool that we use to manage assets while we're alive, and then to transfer the assets when we pass away. So trust, in the greater Austin area, I think in our planning and the people who come to see us, the large majority of people use trusts. And you do not have to have a lot of money. You do not have to be a business owner to have a trust. A trust is just an arrangement that's revocable usually, and you put your assets in this trust. You manage the trust for your benefit, and you can change it whenever you want. But you can put all kinds of instructions as what happens when you die, who takes over, who it goes to, and then what that is a trust that is already in existence, and perhaps we can avoid having to probate the will. And so also if we become disabled, Alzheimer's, dementia, stroke, it's a good way for somebody to be named to just immediately take over our assets and have immediate access to our assets to help us.
And that's not getting into the guardianship or anything.
Right. We can avoid a guardianship that way.
Okay.
That saves a lot of time and money if someone can just step right in and manage our assets for us immediately.
And again, with my realtor hat on, I know when I'm looking at the tax report from the Williamson County Appraisal District, and when I see the list of the ownership identified, and when I see it's a trust, I have to admit it used to freak me out, going, oh no, what is this going to mean? And now I go, yay. It's usually an easier transfer of property. It's done.
It's done. The trustee when someone dies and there's a trust, the trustee can just take over, settle whatever debts need to get resolved, and move the house according to whatever instructions are. We avoid, not that probate is terrible, but it is time consuming and there are a bunch of things you have to do, and we can avoid all of that.
We always sound so anti-probate, but it's really just there are more efficient ways for most of us.
It's a faster, more efficient way to move assets when we pass away, and it's a good way to manage assets while we're still alive.
And, okay, well, let's go. I want to clarify or ask you to clarify. We see the terms, and you mentioned revocable, irrevocable, and family and living trust. What do some of those things mean?
Yeah, so trusts can be set up for all kinds of purposes, all kinds of arrangements. If I'm trying to do asset protection because I'm worried about creditors, I'm worried about taxes, then I might use an irrevocable trust and move assets into something that's irrevocable, meaning it cannot be changed. And what I'm trying to do is lock assets away, keep it away from even myself so that my creditors can't get it. Or I might be trying to put it in a locked up situation so that my special needs daughter isn't disqualified from public benefits. She doesn't have access to it, so it doesn't count against her. So that would be an irrevocable trust. Revocable means I create it and I can change it whenever I want. And I manage it usually. And when we talk about family versus living, if it's family, it's usually because it's for me and my family, so it's a family trust. If it's living, it means it's created and I'm using it now while I'm alive, is what that means.
And well, this is more of a follow-up later on, but I think some of us think, okay, we do our will, put it in the drawer, whatever. I have a trust drawn up, and it's done. I put it in the drawer or the file cabinet. You're making a face. Why are you making a face?
That is the one downside of using a trust, is if you take it and put it in the drawer, it doesn't do you any good. And we have that happen. People will pay money, go through the effort of getting it done, and then not use the trust. So a will you might sit in your safe deposit box or your fireproof box at home and forget about it. But a trust is something that you are going to be utilizing every day. It is your alter ego, and you need to make sure your assets are in the trust, and so you don't just lock it away.
So I don't even know what the best word would be, but forming a trust, having someone draw up a trust for me, that's the foundation. But now I've got to put the stuff into the trust. I think last year when Sarah Kendrick was here, she kept talking about putting it into the bucket.
Yes, that's a great description. You form it, you create it, but then you've got to use it. You've got to put the assets into the trust, and then you manage the assets in the trust. Absolutely.
So that can be a whole nother discussion, but you're right. Some of us are learning that the hard way, or learning that. One of the questions that we often hear is, who's going to be the executor or the trustee? Does it have to be a family member? What if I don't trust my family members to make wise decisions? I'm sure that doesn't apply to anybody here, but I've heard that hypothetically other places. So
it's a fantastic question. You, again, in your will and your trust, you get to choose who's going to manage it when you can't, whether it's by disability or death. And you want to choose wisely, right? So oftentimes, I think Virginia mentioned to me, people want to do it in age order, the oldest kid and the second oldest. That's not necessary, and that's not a legal requirement. If you're going to name children, we always recommend to consider children who are close to you in geographic location, who are able to assist you if you need assistance, who can come in and take care of your property, whether if something happened to you or when you die. So it might not be the oldest kid, because the oldest kid might be living in Africa. The youngest kid might be living in Dallas, and you're here in Georgetown. So it's going to be who's available, who can help, and who's willing to help.
And I think they can and willing. Some people are just more willing to step in that role. Others are kind of freaked out by it, being in charge of something. Business acumen is kind of low for some people.
100%. I mean, some people are great at getting out there and being friends and doing things and being active, but not so good at managing the assets. And so you want to take that into account. You could always name a professional person or a bank as your executor or trustee. So those are also options if you, like you said, don't really trust your children or you don't feel like they're capable of doing the job. There are professional alternatives.
And that's something, because I've had people even this year to say, how do we find that information? I don't have family. My only woman who's spoken with me has a son. He lives in Europe, and that's not very readily accessible to come help her if she needs help. So how do I find this professional support?
Well, a bank with a trust department is a good starting place. So they are very helpful with managing assets. There's also
So it's not just having my financial part. I mean, they can look at the overall.
Yep, they can help you with your house, your cars, your mineral rights, your accounts, your investment accounts at other locations. So if you were to get the support and help of a trustee, being a bank and trust department, they can absolutely help you with everything. There's also independent professional individuals that will serve in that capacity. They're a little bit harder to find, but there are certainly those that are available. And then you have agencies or companies that provide care management services. They don't usually want to manage your money, but they're certainly willing to help you with your health care. And they'll serve on your healthcare power of attorney. They'll meet with you a couple times a year, go over your care, make sure that your doctors are actually telling you what you understand that they're telling you, and then be there if you need them to make decisions for you.
So that's something, Care Partners to Caregivers, I think Josie helps people with that. There she is over there. And by the way, congratulations, she just earned a special certification. It's for limited, really high quality service. So we appreciate her continuing to learn and grow and bringing her great service to us. But that's one. And next month, we're going to be hearing more about that.
Great.
So that's an important part to be aware of. I want to go ahead and transition to power of attorney. You know, we have a durable power of attorney. What is that? What are the limitations of it? Again, who should I give my power of attorney to?
So a power of attorney is a fantastic document, but it does need some thought placed into your power of attorney, because you can make your power of attorney very, very limited. You can make it be effective immediately. You can make it become effective when you become disabled. It can be a general power of attorney, or it can be broad power of attorney. And generally, when you make a power of attorney, you're authorizing somebody else, a husband, a wife, a partner, a child, to come in and access your assets, sign your name, sell, purchase property, pay your bills, all of those things. And so you need to give a lot of thought about who's going to have that authority, who's going to have that power, and how much power you're going to give them, and whether or not there are limitations. And so it's a very good document, but it can be very much customized and should be according to what you need.
And that's one of those, again, with my real estate hat on, but when you hear people say, I work mainly with seniors, and we always want to be prepared. And I often ask people, not to be negative or morbid or whatever, but does someone have power of attorney? We never know. Should something happen, But oh yeah, my son or my daughter, they can do this. They have my power of attorney. But you need to make sure what power of attorney they have. I know in my work, then I always have that reviewed by our title company that we'll be closing with, and the same with a trust. So if you have your property in a trust, and I hope, at least I will say, okay, I need a copy of the trust, or at least a certification of the trust, to take to the title company so they can review it. They're not saying it's good or bad. They just need to know how the property is listed ownership-wise, so all documents will be correct.
Right. They've got to know how it's titled, and they got to know who has the authority under those documents to make the transfer.
So some people think, well, why do you need my trust? Well, that's the very reason. We want to be prepared. And in that type of situation, it's better to do it early on. if you don't do that and you get your house on the market and it goes under contract, that's great. Then they're going to need to see the trust, and it should be fine and smooth. But sometimes it needs to be listed as this. There can be specifics that need to be accounted for.
100%. Every trust should be different and customized to what you want to happen.
Okay. Now, that's durable power of attorney. What about medical power of attorney?
Okay, so one thing I do want to clarify with a medical power of attorney, and even with a financial power of attorney, is you name your agent, and that agent is there to help you, all right? They are not there to boss you around and to take charge of you.
Identify.
That's right. But it's from time to time, I'll have someone in my office, and they'll say, "Oh, I'm mom's power of attorney. She's going to do this," or "I'm taking her to the hospital. I'm going to get this done." Or you don't have that authority as an agent on a medical or financial power of attorney. The agent is your helper, not your boss.
Okay, pay attention to that. And I'm serious about this.
Right.
And now, if you want your kid or whoever to make decisions for you, and that may be the best to do, but think carefully about that. It's back to you being educated, you being empowered. I know how this works. You're here to help me. Now, I know sometimes we have to have some discussions about what, is appropriate, but being informed and carefully selecting the person is critical.
It's critical, and it's critical you understand that you're still in charge. Now, with the medical power of attorney, it only becomes effective when the doctor puts in writing, not just verbalizes, but actually writes in your medical chart that you are not competent to make medical decisions, all right? That's very important to remember, because so many times, again, the daughter is taking mom or dad to see the doctor, and it's the daughter trying to make the decisions. And mom and dad are just old, right? They're perfectly competent. They're moving a little bit slower, not getting around as well as they used to get around. But they're certainly competent. That doesn't give the daughter the right to take over, okay? The daughter's the helper. The person needs to make their own medical decisions.
And you can say, I heard that at the Seniors Living Smarter seminar, and I am the person in charge. And go from there.
That's correct.
So and he stressed, it's not just saying they're you don't use the word incompetent. They're not competent, I guess is better.
Yeah, they're incapacity. Loss of
that's
capacity is kind of the terms we use nowadays.
Okay,
Yeah.
have to have the right language here. So that's the critical part there, that it is in writing,
It is
not
in
just...
writing, not just verbalized. It has to be in writing before they would have any authority to actually say my decision controls. Okay. But unfortunately, children take advantage of that regularly, and we as adults and parents, we don't have to let that happen.
Okay. And then closely related to that is, unfortunately, we see such an increasing amount of dementia and people affected by that. And how does that relate to this?
So, dementia, as we're living longer, right, we're noticing it much more, and it's much more prevalent. So the biggest thing we need to do is make sure we're getting our planning done while we don't have dementia. That's really the most important thing. In addition to all the things they tell you as far as eating and exercise, you need to get your planning done early so that if the time comes, the right people you trust are helping you with your assets. If you come to see me and you've already been diagnosed with onset of dementia, then what we're going to have to do is work with your doctor to make sure you have capacity to do the planning now. And I would say if it's onset of dementia or Alzheimer's and it's really early, we can probably still do planning 8 times out of 10. But if it's moderate to severe and you come to see me and say, well, my wife's had dementia for about 8 years now, and we need to get a power of attorney and we need to get things done, it's too late. And so we need to be mindful of that.
And I know that's hurtful to some people. We want to protect people, but we are protecting people in the long run by being prepared. And so we just encourage people to be prepared.
Mm-hmm.
And I already mentioned guardianships, kind of like how do we, but there's a lot of concern, pros and cons to guardianship. Who needs a guardianship?
Yeah.
What are the limitations? What are the benefits?
So guardianship comes into play when we have an individual who has lost capacity and either did not do powers of attorneys or a trust and make planning ahead of time, or they may have done that and now the family is fighting, or mom may have done planning, named the right person as her agent and on her trust, but now she's very, very combative, aggressive, difficult. And remember, when I'm on the power of attorney, I'm not her boss. And so I may have to go get a guardianship so I can become the boss. If I become guardian over my mother, I can become guardian of her person and or her estate, her money. And that puts me in charge, kind of almost like a parent-child relationship. But remember, it doesn't just make me the boss, it also gives me a legal duty to take care of mom at that time. I actually have to make sure I manage her money prudently, and I have to make sure she's taken care of once I'm the guardian. And so when we find ourselves in a situation of needing a guardian, it's usually because they didn't do the planning and lost capacity. Maybe the kids are fighting, maybe second wife and children from the first marriage are fighting, or maybe mom's just very, very combative and aggressive.
So again, be aware, plan ahead, and plan ahead would solve a lot of problems for us.
It really does.
What about directives to physicians? What about the do not resuscitate? Okay, I have a do not resuscitate, so does that automatically go into effect in all situations?
Yeah, so do not resuscitate can be in hospital or out of hospital. You can do it either way. It only applies to our heart and our breathing, all right? And so what it says is, if I stop breathing or if my heart stops beating, then I don't want you to give me CPR, right? So if I'm sitting here and I fall over right now, I want all of you to jump up and help me, okay? All right? But if I have an out-of-hospital DNR, it's signed by me and my doctor. We both have to have it signed. And I'm saying if I fall over, I do not want you to help me. I want to die. And that those types of documents work best when you're bedridden and you're ready to go. All right. So you might be at home, you might be in a nursing home. And you're usually either bedridden or your mobility is usually severely limited, and it's time. You might be very sick or something like that.
And isn't part of the concern that the document has to be available?
Oh, correct. Well, good point. So if I have that document and I'm at home, my heart stops and somebody calls the ambulance and they show up, if my document is not immediately displayed along with an ID, they're gonna work on me. They're gonna revive me. They're not gonna sit there and say, well, go find that. And when you find it, if it takes a few minutes, that's okay. They're not gonna do that. They're gonna go to work on me right then. So if I really want that, that's why it works best if I'm kind of bedridden, because I could have it taped to the wall with a copy of my ID.
So that's one of the things, I know some of us, when we are, at doctor's offices, there are questions they ask, but especially if we're in the hospital, do we have that? And it's always, well, I have it, but who knows where it is, or is it on file with that hospital? How do you know how to keep it?
So you should, have your if you have a DNR or your living will and a healthcare power of attorney, you should have those documents located several places. You should have them on file with your primary doctor's office. You should have them with whoever your agent is. So your spouse or your children, they should have them. You should have them readily accessible at your home. And even in today's age, it would be nice if you were savvy with technology that you could save it as a file on your phone. Those are the places you really want to have them. We travel, we're out at the grocery store, we go see a children or grandchildren. If something happens to us, we want to have accessibility to those documents.
And when you mentioned the phone, that made me think about one of the concerns we have is becoming more of a concern, just that whole, well, it's in my phone, but does somebody know how to get into your phone? It's on my computer. Does somebody have access to it? The digital assets that we talk about, accessibility, words of wisdom about that.
So you need to think of your digital assets very much like you would have thought of just a bank account with a bank statement. My wife and I try to keep a listing of all of our bank accounts and all of our digital assets in our passwords and our usernames available. So if something happens to us, our kids can readily get to that. Companies are starting to recognize now that it's a little bit more difficult when you have digital assets, and they are starting to allow you to designate with the company who can have access to your account when you die. Apple, for example, does that. So if you have an Apple phone or an Apple computer, you can designate who Apple should give access to your account to. And you're going to start seeing more and more companies do that. But you don't have to do it that way. You can have a listing. You can give your executor, your power of attorney agent, the ability to access those things. It just has to be in writing. I just recently had a gentleman who died in Las Vegas. He was about 45 years old, and he was single with no children, and he had no planning in place. And the family couldn't access his computer or his telephone. And he didn't write anything down, and he didn't share it with his parents. And so that was a process we had to go through to try to get access to those.
Something to be so aware of. I think Brielle just stepped out. She and her, oh, there you are. Brielle, why don't you're so good at this. You and your family are so organized. Can you just at least make us aware of the apps or whatever, briefly?
So my husband and I, we use an app, Bitwarden, where we can get into, we have all of our passwords and everything shared with one another so we can get into things, and our kids know how to get into the master account there. With my parents and my sister, we all have copies of the passwords, information, attorneys, accountants, all of their information sealed in our safes. So each of us have a copy of that so that if anything were to happen to any of us or a group of us at a time, somebody would have access to get into my parents' and my sister's accounts. So we all have access to that.
And we may even list some of those in the follow-up, but she's great to visit with about this. And for some of us who are still, we use our computers and phones, but we also kind of like pen and paper, pencil and paper. We used to say, don't write your password down. Some of us are freaked out about that. Well, by the time you have a jillion passwords, and usernames and, trying to keep track of it, at least having it, a hard copy is a beginning point. Some of you, I just want to mention as we organize our materials, we'll talk more about this next month too. I don't like to do promotions for materials or products, but there's a great one. I have a hard time saying it. Knockbox, not the Knox box that has your key and information for first responders, but NOK, Knox box for next of kin. Now we can make our own files and notebooks of all this information, but so I know I went ahead and got it this fall. It can be such a great gathering spot for everything. You can put your wills and medical power of attorneys and all of that in there, trust papers. Do you have a car loan? What's the bank? What's the account number? All that information. So I just, not that you have to use that product, but it certainly has been helpful for us as we try to pull that information together. What's that? What is it? What was the name of it? I have a hard time saying it because I want to say no. It's NOK. If you look it up online, for next of kin, NOK box. 2 words. Mm-hmm. You're welcome, and we'll put that in our follow-up. But I just mentioned that as we said, having these things drawn up, but then you have to use them. You need to make people aware of them, and they give all kinds of suggestions, what copies should be made available to other people. But when we were talking about knowing passwords and, you just see these situations where a spouse passes away. I mean, you just shared someone didn't even have a spouse, but the spouse doesn't know. They can't even get into the spouse's computer, and even if they do, they don't know passwords to get into any of the files. It can be, so that's just one thing about that.
Well, Google, if you use Google Chrome, under settings, you can just go under settings and click password, and then you can share your passwords with your family members right there. So it's a very easy way to do that. Apple also has something similar to that.
So there's another next step for you to put down possible, think about that, whether or not, and that's something that we have pretty available. And for people who need more information, we'll figure out how to help you with that. I want to kind of skip down to that, but this ties into next month too, and we'll be talking about, end-of-life planning. What about the designation of agent for disposition of remains? What is that? What does that accomplish?
Yeah, so this is a document that allows us to decide who's going to take possession of our body and get it disposed of, right? Disposition of remains, whether it's going to be cremated or buried. If we don't do the document, the law says our spouse gets to make that decision if we're married, and that's fine 50 or 60% of the time. But often we have a second marriage, a second wife, and children from the first marriage. So if I have a second wife, she may want to bury me next to her first husband. I might want to be buried next to my first wife, right? And I could designate who's going to take my body and make sure it goes where I want it to go. It could be my older son. It could be my second wife. I get to decide that in writing. And we don't want to put that in our last will and testament, because our last will and testament doesn't usually get read or paid attention to until after we've been buried.
So that would not help.
So it's not helpful, right? So we would use that document. And truly, if you have a blended family, a second marriage, and kids from outside that marriage, this is a document that you really need. I've had to mediate and go to court over who's going to dispose of the ashes. Who's going to, we've had a couple of situations where the body was frozen until we could resolve the fight. So if it's not a traditional marriage, this is a very important document.
And where do we find that document?
Usually your attorney's office, whoever you use for your attorney's office, they can help you with that document. Sometimes funeral homes, when you do prepaid funeral planning, sometimes they'll help you with that as well.
So again, that's a topic we'll follow up next month, but I wanted to start it this month while we had an attorney here and, and get his perspective on that. I want to open it up now for questions from the floor. And yes, let's see. I'm trying to remember. Oh, yes. Well, yes. Sarah Elizabeth from Rainey and Rainey said she would be a mic runner for us today. And we appreciate her help there with this. And Josie Zamora, we invite our educational partners to be mic runners for this. And by the way, I failed to think, Care Patrol, that you are our PIN sponsor today, right? I don't see him right now, but yes, thank you for providing pins for us. One of the commitments we make for our seminars is they are informational, educational. So it's not like a vendor fair, trade fair, where you go and you pick up all the little bits and pieces of candies and koozies and key rings and you fill your little tote bag with stuff. What are you going to do? Well, anyway, we won't even, most of us are in the downsizing, decluttering sometimes, so we don't need that. We tell our educational partners, we will, if you would like to be a water sponsor, Seniors Living Smarter was the water sponsor today. Care Patrol was our pen sponsor, and our mic runners will be Care Partner to Caregiver and Rainey. So that was an explanation about that. If you have a question, if you'll raise your hand, and one of our mic runners will come around. Okay, let's come over here. Right, Sarah Elizabeth.
Getting back to wills, I think it would be helpful for some here to know what happens to you at time of death in Texas if you don't have a will.
Yeah, so if you do not have a will or otherwise made arrangements for your property to transfer, what we do is we open up a probate estate without a will. And we appoint, instead of an executor, we appoint an administrator over the estate. And as a part of that process, we have to have a legal determination as to who your heirs are. So we have to have a judge, we have to have another lawyer, we usually sometimes have to hire a genealogy company, maybe not.
I think you better have a will.
Yes, so we can do it, and it's easier if we can figure out who all the heirs are easily, and then they all agree on how to proceed. But if we can't figure it out easily, or if they won't agree, it can get pretty expensive.
And so that's when we do the heirship of affidavit. That's where we...
An affidavit of heirship is the beginning of the process.
Okay, and that's family members, but then also non-related people have to be
involved.
contacted, right?
That's correct.
So it sounds like the bottom line is go get your wills and be prepared. Okay, good question. Over here, somebody, okay?
Hi, good morning. First of all, on the ladybird, is it deed? Is that the correct term, ladybird?
Yes, ma'am. It is a
Okay.
deed. A lot of times people use it interchangeably, Ladybird Trust,
Yeah.
but it really is a deed.
Okay.
Okay.
So is that only a Texas document?
No, there are other states that have Ladybird
Okay.
deeds, but not all of them have Ladybird deeds.
Okay.
Okay. I would say the majority of states have something similar to it, but they don't. But it's a little different. But not all states have a
Okay.
deed like that.
And one more thing, what's the downside of that document?
There really is not a downside at all. The one thing you do need to be aware of is it's specific to that piece of property. So if you have a
okay.
house,
Maybe
you do a
that's-
Ladybird deed, you sell the house, you
Okay.
buy a new one, you need a new Ladybird deed.
Okay, that's what I thought. Okay, thank you.
Okay.
Back here, Sarah Elizabeth, okay.
Yeah, my question is, my husband just passed 7 weeks ago, so I'm right in the middle of all this stuff. And I'm also looking ahead, and I did get the knock box. I just got my package the other day. It's very impressive, it's very concise. I'm going to try my best to get it done for my kids. But I'm also being told that in the state of Texas, and I'm a transplant, I've only been here 3 years. I'm also being told that not only do I have to have in the state of Texas a will, last will and testament, but I must have a living will and an advance directive. Well, I've read both of those, and I don't understand the difference and why I must have both.
So in Texas, we tend to refer to an advance directive, multiple documents as an advance directive. So some people will refer to a healthcare power of attorney as an advance directive, or medical power of attorney as an advance directive. Some people will use those terms interchangeably. So when you hear them saying you need both, my immediate assumption, obviously I don't know for sure, but my immediate assumption would be that they're wanting you to make sure you have a healthcare power of attorney, a directive to physician, which is the living will, but technically they're the same document, okay? But they're wanting you to have both. And they may also be wanting to refer to you to what we often want everybody to sign is a HIPAA authorization, all right? And so those are 3 documents we want everybody to have. And so my assumption would be they're just trying to make sure you have all 3 of those documents in place.
Thank you.
Okay, Jim, I think.
What do we need to do or not do with just a single heir?
If you have just one heir,
Yes.
you just want to figure out what planning you need to do to make sure it transfers to that one heir as easily as possible. It might be just a last will and testament. It might be a simple trust. It might be a combination of beneficiary designations and a ladybird deed. So there are just different ways to go about it, but you just want to set up the most effective way to transfer everything to that heir.
And I think the important part too is there needs to be something in place to some instrument
I mean,
to make it work. It's
to make
not,
it easy.
well, everything's going to my son. He's my only heir, if that were the case. But once again, unless it's with the trust or unless it's probate, if it's just a will, that's not going to help.
Yeah, so you want to make sure you do something. Don't just do nothing because you only have one person. I mean, it'll all get to that person. It's just going to be a little bit more complicated to get there.
Okay. Other questions? I think up here Giselle has a question. Josie, I'm sorry. We'll go back there.
What is the
Oh, it's
difference?
Joanne, I'm sorry. With your mask on, I thought you were somebody else. There she is.
What is the difference between an executor and power of attorney?
Yeah, so the executor is the official title we give the person who probates the will and manages your estate when you die. An agent on a power of attorney is the person who helps you while you're alive manage your money while you're alive pursuant to the power of attorney. So that's just the nomenclature difference. No, once you die, your power of attorney dies with you. So the moment you die, your power of attorney dies, and then we have to...
Yeah, their relationship.
The document dies. How's that? The person doesn't die. The document dies. your agent hopefully still lives, but their power goes away the moment you die. So then we start talking about the will or a trust or deeds. That's what we start talking about.
One thing with power of attorneys, again, from the real estate world, if you are using, someone will be signing on your behalf using power of attorney for the sale of a property, which this can happen. It may be that, you know, you're traveling and you're not going to be able to be there, or there can be reasons why. That you can have your power person with the power of attorney to sign. Generally, the title company is going to need to speak directly with you. If I'm not there to sign that I'm selling my house, and my son is signing on my behalf, the title company is going to need to be able to reach out to me to verify that I'm aware that's happening, and my son is not just selling my house without my knowledge. So it's just, you know, we have to plan ahead for that. Yes. Something from the real estate world. Okay, back here and then up here. Okay.
Okay. My sister and I inherited a big piece of land, undivided. So what happens if one of us dies intestate, the first person dies intestate?
Well,
So repeat her.
so this lady inherited a piece of property with her sister, and they are now co-owners of this property. And what happens if one of them dies without a will or some sort of arrangement to transfer that half interest? Well, that person's heirs would have to be determined, and then that person's heirs would inherit their undivided 1/2 interest of that estate, of that land, is what would happen. And so that would be the process. So if you're single and have one child, your one child is your heir. You know, if you're married and have children and you die intestate, we're going to have to decide, is that property separate property or community property, because that changes who your heirs are. So in your situation, you and your sister really need to do some sort of plan who gets what when one of you passes.
All right, let's see. I said we would go, okay. Well, let's come over here, and then we'll go right back there. Okay.
This is a quick question. First of all, thank you for all the information. My question is one that no one else is willing to ask.
Now, if it's too personal, you can follow up afterwards, but
I just would like to know if there's a fee schedule posted anywhere.
There is not a fee schedule posted anywhere. We have general prices, but depending on how much customization we have to do, that general price will change. We do keep a fee schedule in our office, so it's not an arbitrary number, but we do adjust those numbers up or down depending on what we have to do. Mm-hmm.
that was a good question. Mm-hmm. Okay. Let's see. I said we'd come over.
Is there a hand over
here?
Oh, I'm sorry.
Oh. Okay, then go ahead.
you said you have to have a power of attorney first and then a trust?
Not necessarily. Those are going to be two separate documents, and we would usually do them at the same time when we're doing our planning. The trust, if you have a trust and your assets are owned by the trust, then you and then your successor trustee would have access to it without the need for the power of attorney. So they don't necessarily have to have one first and then the other.
Well, then, where does the will come in?
Well, if you have a trust and you put all your assets into the trust, hopefully you'll never use your will.
Okay.
Okay? All right, so it would be, you would have a will, but hopefully we would never need it or use it because our trust is our document that manages our assets while we're alive and then says what happens to it when we die.
So basically, that's the best one to have.
It's a really good way to do things.
Thank you.
We often hear, although it gets divided up in different ways, what are those documents that we all need to have in place? So we often consider the will.
The will, your power of attorney, financial power of attorney, medical power of attorney, living will, HIPAA, maybe a trust, maybe a ladybird deed.
Okay, we usually stop with 4 or 5, but you're right. I mean, all of those are the more prepared we want to be. There we go. Okay, Josie, did you have someone over in this area with a question? No? Okay, oh wait, Catherine.
I've got two. Let me see. Okay. Is probate required if you have PODs on all of your accounts and you have no physical property like a home? Mm-hmm. And the other one was, could you talk about the importance of funding the trust?
Yeah, so if you have PODs on all of your bank accounts, a payment on death account, so that if you work with your bank and you sign a document that says, when I die, I want you to pay the money in this particular account to somebody particular, and you name that person, when you die, the bank is going to give that money to that person once they present a death certificate and an ID, all right? And so that's an automatic transfer. It doesn't matter whether you have a will or not in that situation, all right? Same way with a trust. It doesn't matter if you have a trust or not. If you have a trust, though, you would not have a POD on your account. Your trust would say who gets the money and how they get it. You generally wouldn't do both.
And then what was your second question?
Oh, yeah. So funding the trust is kind of what we touched on a minute earlier. If you have a trust, it doesn't do you any good to get it prepared. You have to use it. You have to go to the bank and you have to take your checking savings account. You have to go to Fidelity and move your investment account, and you change those accounts into the name of the trust with you as the trustee. That's what we call funding the trust, is when we put the assets into the trust so that the trust owns those assets. If you don't do that, then the trust doesn't own them and the trust doesn't control them.
So the same with property. I
Same
don't
with
know.
property, same with a house, land.
You have to, and I don't know, okay. Full disclosure, we used to do a trust with Rainey and Rainey, and you all did put the
house
property in there.
Yes. So we do a deed transferring the property into the trust. That's correct.
So, I kind of forgot about you've got to put stuff in the bucket. Checklist, we got the trust. Oh, you're not through yet. Okay. Somebody in the room reminded me of that. Hi, Scott.
Hey, Virginia. This group would benefit from realizing something I hadn't heard yet was the difference between the will and the trust when it comes to public versus private. Thought you might want to touch on that.
Great. Thank you, Scott. So when we die, if we're transferring assets by a will, it has to go through court. And just about everything in court is a public record. And we file an inventory with the court, which is a complete listing of all of our assets, our bank accounts, our investment accounts that Scott's managing. Everything is listed, okay? With a trust, nothing goes to court. It's not public. We have the trust own the accounts. We have the trust own the property. We die, we name who takes over, and we give them instructions what to do, so it's private. And that's very important to a lot of people.
Okay. Where? Oh, right there, Cheryl.
Is there a way you can set things up so it's most advantageous tax-wise for your the people that inherit your money
Yeah,
and assets?
it's a great question, and it very much depends on how much you have, how important that is. It's also so two things to be aware of when you're talking about taxes. First, if it's an estate tax concern, right now, today, each person can own $14 million in assets and die, and there's no estate tax. Okay, that changes next year to $7 million.
Some of us said, okay, I'm all right.
All right? But the second thing to be aware of is if you have land or a house or property, real property, you do need to be mindful. Sometimes people want to just transfer the house today to their children instead of having it transfer when they die, and that there is a tax consequence for doing that, okay? If I inherit a house, I get the house at the value it's worth the day it dies, so if I sell it the next day, I have no capital gains tax. But if my mom gives me a house today, and then she dies tomorrow, and I sell the house, I'm gonna pay a capital gains tax on the difference from now to when she bought it. And if she owned that house for 30 years, it's 20% tax, so it could be a fairly decent tax. So those are two things to be aware of. The capital gains tax, if I make a gift instead of inheriting it, and then if I have a lot of money, 7 million or more, then I need to worry about estate taxes.
So if you have, if you leave stock, your portfolio to your kids.
Yeah.
And, okay, so they determine the value the day you die.
Yes.
So if it increases in value, they have to pay the difference.
Yeah. So if you left me all your Microsoft stock the day you died, it was worth $100,000, and then I sold it the next day and it was worth $110,000, I would pay a capital gains on the $10,000 because I inherited it from you. I got it at $100,000.
We're going to spend more time on these financial questions. I don't remember what month. I'm looking back. Scott Olson will be with us to talk about more of the financial questions too. So other questions that people had? Rita.
I hate to bring this subject up, but we do live in the wildfire capital of Texas, I believe. Mm-hmm. Is it prudent to have my attorney keep a copy of all my records in the event that they are destroyed and my family's safe?
Yeah, for sure. I think most attorneys will keep a digital copy of your records. So I think most will do that anyways. And if they won't, you could ask them to. And then the key is your family needs to know who your attorney is so that they can get a copy from them. Also, we can use a copy if it gets burned in the house for sure. But if it doesn't get burned, then we try to use the original.
Can you actually go to probate with a copy?
If it got burned in a fire, yes. If I can absolutely do that. There's some more steps involved, and we have to show what happened to the will, and it got burned in the fire, and that you didn't burn it on purpose. Okay. Those kinds of things.
Okay, great.
So that digital world is changing too, and the more that
you still have to have the original, even in a digital world. So the copies are helpful, but you still need to safeguard the originals because we still have to use those.
Okay, I think. Oh, okay. We're going to have one more question from Larry. You had a question?
This has to do with Social Security. I got a text from a friend of mine that just said this, and I do have a will. Did you know that as you age and you need more and more medical care, that if your funds are in a trust, Social Security can't touch it? So if you put all your funds in a trust, Social Security has to pay for all of your medical care without repercussion to you regarding any of your funds or assets.
That's not correct.
I didn't think so.
So the short answer, that's not correct. Okay.
That was that one. Now I know you saw your handout from Rainey and Rainey in your packet. When we do our follow-up email that Brielle will be sending out, it will have a reference to an extended document that you all had prepared. What I thought, we're not going to get into this today, but maybe Scott can help us with this later, is that whole question about Medicaid and spend down, and there was some reference to that, I think, in the document. If that's the question you need, you can probably visit with James, or Chris will be with him. Sarah Elizabeth is their office person, so when you call over there, that's who you speak to. And there's Chris. He'll be over at the table, too, for questions. Okay, one more question, buddy, and then that's it.
Our attorney did a lot of the things we've discussed or that you've brought up, but he didn't die, but he retired. Mm-hmm. So is it a good thing to get a new attorney to go over all these things? We haven't looked at them in a long time. So.
I would say the short answer, it would be a good idea to get a new attorney to go over it, make sure everything looks good. It's been a while since you looked at it, make sure that doesn't need any changes. Okay. And if it does, then you could update it.
Okay, yep. Thank you.
Mm-hmm.
Okay, I'm going to cut this off, and people can, like I say, they'll be at wherever their table is over there, I think down that way. They can answer questions. Thank you so much
Thank you
for
very
your
much.
time. And I want to, so I'll let the educational partners move back to their tables. And Brielle looks like she's trying to tell me something. I'm going to say one thing and see if she probably has something else. In your packet today, we always have our feedback forms, and I really hope you'll see this as a communication tool. It's helpful for us to know, if you can share, was this helpful for you? Take a minute to jot down some responses to that. And then on the back where you can put your contact information, we do have the statements there. If you would like to be registered for the March seminar, Taking Control, Empowering Yourself with End-of-Life Planning, yes, we do need to do that. You can register, but guess what? If you mark yes on that, make sure you put your name on your form. Anyway, sometimes we don't know who that was. But we also added, if something should come up between now and March, and you're not going to be able to attend, if you'd let us know, that would be helpful as we prepare materials and so on. If you're not on our email list, postcard mailing, you can put that on here. And if you would like a complimentary consultation, I visit with you just about the whole downsizing process, or we have a downsizing club, we can visit with you about that. I want to thank you all very much for being here. Again, thank our partners and thank our presenter, and look forward to seeing you in March.